We're seeing a lot of Canadian businesses operating in the US. There's a huge opportunity there. It's a big market. A lot of them are doing very well. And of course, one of the really important things to do is to protect your valuable intellectual property when you're moving into another jurisdiction. So I'm lucky to have with me my colleague, Lisa Statboy. Lisa is an intellectual property lawyer and a registered trademark agent, and she's going to talk to us about trademarks today. So Lisa, just for a really basic question, what kinds of things can be protected by trademarks?
Thank you for the question, Rob. Trademark law is concerned with protecting brands. So when we say brands in trademark law, what we mean is designations of source. Traditional trademarks are marks like word marks and design marks, what we would commonly call logos. But in fact, now in modern times, we can even protect by trademark registrations non-traditional marks like scents, like colors, and even some shapings of wares.
Right, so we're talking about protecting shapes, designs, logos, and other things like that. Now, if you're doing business in the US, at what point should you actually take the step of registering a trademark there?
We, as trademark agents, recommend that clients begin the trademark registration process as soon as possible. My clients often struggle with that exact question, and in many cases, their thought is, because they have limited time and resources, their thought is, well, we'll wait until we get going. We'll wait until we know that the US is an important jurisdiction for us. And that's when we'll proceed to protect the trademark that our goods and services are associated with. But that can be a very troublesome strategy for a couple of reasons. The first is that trademark registration provides, in fact, statutory damages to the trademark registration owner. Therefore, if you're already starting to offer goods and services, sell goods and services into the US from Canada, and somebody has a trademark registration for what you're thinking of as your brand, that there's potentially very significant damages that could be assessed against you for trademark infringement, and those are statutory damages. So it's important that you get ahead of the game and that you seek protection for your trademark early as opposed to waiting. The other reason to apply early is that the trademark registration process is a first in time, first in line kind of system, meaning that it's important to be early and ideally first in the queue. If a competitor or another trader gets ahead of you in the trademark registration line, they are potentially going to have better rights than you to that. So we do see in many circumstances that clients have waited to take those steps to protect their trademark in the US, and they've really lost out in terms of their rights and their priority that they otherwise would have had if they had applied earlier.
So Lisa, thanks for that. You've just given us the very tip of the iceberg of the wealth of knowledge that you have in this area. So great information. Thank you for your time.